question.
I appreciate, Dr. Greve, you're leading to my question directly, and I'm just a simple dirt lawyer from Idaho, so many of this complexity escapes me, but I do cut my spaghetti. So my poll star is that it seems to me that the Constitution, as you allude to, preempts Congress. And so my question to Dr. Greve and perhaps to Ms. Sharkey is, to what extent do you find, and to what extent do you think that they ought to find, start with, you know, in the modern cases, they start with a Constitution that says, well, this is the power that Congress has vis-a-vis the states, vis-a-vis the people. In your research of the modern cases, do they do that anymore, or is it all just swept away?
Do you want to?
No, you start.
So I guess you're talking, basically, I mean, certainly in the products liability area, there are, I agree with Michael, there are basically seemingly no limits to congressional authority to regulate national products, and they've done so in a sort of piecemeal way. The preemption cases do start, I mean, they talk about the supremacy clause, and they talk about the fact that if it's valid federal law, it will preempt state law. In the products area, a lot of the fighting is over whether or not tort law, you know, common law claims are the same as regulatory or statutory type claims. But I think that, I mean, the only other thing I guess that I'll say is that there's been some historical work talking about how displacement in, say, the 19th century, early 20th century was much more about exclusive federal versus state spheres of activity. And then there's been a shift in preemption analysis towards an obsession of the intent of Congress. So there's not much questioning about Congress's authority to displace state tort law in these areas, but all the fighting is now over the reading of congressional intent, which gets into purposes and objectives of the statute, et cetera. On this particular court, it seems like Justice Thomas, with his concurrence in Wyeth, is showing the most verve for, I mean, he explicitly says he wants to get out of the business of implied obstacle preemption, et cetera. But what's interesting to me is that his view, he stands alone with, so I don't see much support from either others who have allied with him in different preemption contexts for that kind of view.
I just want to sort of add to that point Kathy made, and it too is about the Justice Thomas position. What is interesting about his position in Wyeth is this: he makes the point about enumerated powers, to which you alluded and to which Kathy now alluded. He then seems to think that that goes together with skepticism with respect to preemption, even in areas where Congress undoubtedly has the authority to regulate. And historically, that ain't so. The way the enumerated powers doctrine worked when it was still in effect was precisely what Kathy says: mutual exclusivity, or as Richard Epstein and I say, one problem, one sovereign. There can't be any overlap. And what that means is you need a preemption doctrine that makes your teeth rattle. There's no congressional intent, right? The official doctrine in the same court that gave you Hammer versus Degenhardt was, the minute Congress says peep, everything in that entire field is automatically preempted, regardless of whether Congress intended that or not, unless Congress tells us otherwise. End of debate, out of here. I have a lot of sympathy with that baseline. That's probably water over the dam, but what you want by way of making sort of a fresh start is you want to have a sort of common law-like preemption doctrine that approximates that baseline of mutual exclusivity as closely as you can.
No, I'm not going to take you on that. The gentleman from Idaho, I just wanted to say the problem, in part, is the way the court has construed the Commerce Clause, and those who thought maybe they were starting down the road in Lopez found out that the road ran into a big roadblock in the Reich case, the marijuana case, which I was a co-author of a brief, and also in the partial birth abortion case, where, after all, one is hard-pressed to understand what the in-commerce aspect of a partial birth abortion is, and nobody paid any attention to it in any of the courts, including the parties, I might say, who were challenging this statute because it was, well, whatever it was, they were going to not challenge it on that grounds. So if Congress is doing, if the court is letting all of those things go by the board, although Thomas did have a footnote saying that Commerce Clause was not directly at issue in the case, and even though, of course, it's the underpinning for the statute, he wasn't going to rely on that amicus brief on that count.
Professor Selman.
I was interested to hear Alan Morrison say that Congress could not and did not consider many of these issues that come up in these cases, and Dan Troy say that the agencies also often lack either the ability or the incentive to consider them because there are just too many of them, they're too complex. And I wonder if neither Congress nor the agencies are actually capable of properly considering these issues and giving them the attention they deserve, does that not suggest that maybe the federal government has taken on too large a regulatory sphere for itself in these areas, that given that you have, it seems that what you have is a classic problem of central planning where the planners lack the information or the incentives to actually organize the parts of our economic and social life that they've taken upon themselves. Perhaps in the interest of creating more dissension on the panel, one very small note in the partial birth abortion case, Justice Stevens actually did ask about the Commerce Clause underpinnings of this at oral argument, so ironically he being the author of the Raich opinion, so maybe the answer would be, well, what you said in Raich, but it was brought up. But that's not my question. My question is what I said before. Well, thank you.
Well, let me take it on in a potentially controversial manner with the audience, perhaps, and not necessarily with the panel. As libertarian as some of my instincts are, I think that there's a pretty good argument for a federal Food and Drug Administration, as to pick up on what Michael said, one problem, one solution. I don't think we would be better off as a country if we had 50 state FDAs. The point I was making is not that the FDA lacks the ability to address the question it is really supposed to address, which is the labeling of the product effective? Is the product safe and effective for the purpose for which it's intended? Is the labeling adequate? What I suggested was that to expect, just like to expect Congress to come up with a clear statement rule on preemption was unrealistic, to expect the scientists who are doing their very important day jobs of assuring that these products are safe and effective for the purposes for which they're intended, under the conditions of use in the labeling, that they're also going to sit there and say, oh, is this decision preemptive? That's probably expecting a little too much. But I mean, if you ask me to live in a world of 50 state FDAs plus the courts, or one federal FDA, with or without the courts, I want the one federal FDA because at least we can go one place where we can get one marketing authorization to market the product on a country-by-country basis.
Can I just be clear about what, I don't expect scientists to use the magic word preemption. That's not what I was asking for. What I was asking for is if there's a dispute about what ought to go on the label, it ought to be clear in whatever the communications are back and forth, what evidence was presented, that is, what types of risk were presented, and the agency has to say, we think that those are not significant, or they are significant, or the more information is not necessarily good or not. They don't have to use any legal words or other kinds of words. The whole point is to see that the agency addressed the actual issues in the case and not somebody claiming that everything is preempted because the agency didn't insist upon, because the agency only insisted upon A and B and never thought about C, D, and E.
Just one quick note, because I agree in part, which is that sort of with this agency regulatory review, at the time that the agency is deciding to regulate an issue or not, they have all sorts of task force that get together, their findings. I've looked at a lot of these kinds of documents. I do think, though, and Dan didn't put this fine point on it, but I do think there's then a strategic danger, right? If you got the world to shift to this, great model, or a model that I think would be pretty good, then there is this strategic element that the FDA contemporaneously, at the time that it's reviewing this risk information, et cetera, is going to know down the road that there's potentially court review with preemptive effect. So I do think it's a rife concern.